You've heard it 100 times. Maybe from a cop show, maybe from a true crime documentary, maybe from the back seat of a squad car in some movie you half remember. You have the right to an attorney. If you cannot afford one, one will be provided for you. 8 words most Americans could recite in their sleep. Here's what nobody tells you. For most of this country's history, that sentence was a lie. Not a lie in the sense that someone made it up. It's right there in the Sixth Amendment, written in 1791. The accused shall enjoy the right to have the assistance of counsel for his defense. But for 172 years, almost the entire lifespan of the United States up to that point, courts read those words to mean something much smaller than what you think they mean. You had the right to hire a lawyer. Nobody said anything about what happened if you couldn't afford one. So ask yourself, if you were arrested in 1955, broke, scared, standing in front of a judge who'd already made up his mind, what did you do? Who spoke for you when you didn't know the law well enough to speak for yourself? And what happens to innocent until proven guilty when only one side in the room actually knows how a courtroom works? A break-in at a Florida pool hall, a pencil and a piece of prison stationery, 9 teenagers dragged off a train in Alabama, a phrase, special circumstances, that quietly decided who got a lawyer and who didn't, county by county, judge by judge. A woman laughed out of a courtroom in the 1890s for suggesting the state should pay for criminal defense at all. And a convicted drifter with an 8th-grade education who taught himself enough law behind bars to take on the United States Supreme Court. And win, because that's really what this story is about. Not lawyers, not paperwork. It's about what happens when the country that invented equal justice under law has to decide whether that promise was ever meant for everyone, or just for the people who could afford to cash it in. To understand how strange this all is, you have to go back to the very beginning, to the men who wrote the Sixth Amendment in the first place. The Bill of Rights is fresh ink, and tucked into the Sixth Amendment, alongside the right to a speedy trial and the right to confront your accuser, is this line: the accused shall enjoy the right to have the assistance of counsel for his defense. On its face, it sounds like exactly what you'd assume it means. You get a lawyer. Case closed. Except that's not how it was read. Not for a very long time. For well over a century, American courts interpreted that clause narrowly, almost defensively. What it guaranteed, they said, was simply this: the government could not stop you from hiring your own attorney if you had the means to do so. That's it. It wasn't a promise that a lawyer would be provided. It was a promise that nobody would be blocked from bringing their own. The distinction sounds small. In practice, it was the difference between having a defense and having none at all. Think about what that meant on the ground. If you had money, the Sixth Amendment worked exactly the way you'd imagine. You walked into court with someone in your corner who understood procedure, who knew how to cross-examine a witness, who could spot a bad piece of evidence and get it thrown out. If you didn't have money, the Sixth Amendment simply didn't apply to you in any meaningful way. You stood in front of a judge who'd gone to law school, across from a prosecutor who'd gone to law school, and you had gone nowhere. You were expected to understand the rules of evidence, object at the right moments, cross-examine witnesses, all while possibly not knowing how to read. And this wasn't some rare edge case. This was the default experience of the American criminal justice system for the vast majority of the poor, for well over a century. Historians estimate that in many state courts, the majority of criminal defendants faced trial without any lawyer at all. Not because they waived the right, but because there was no mechanism to give them one, even if they'd asked. Innocent until proven guilty is one of those phrases that sounds like a guarantee. It isn't, really. It's a description of who has to do the proving. And if you don't have anyone in that room who knows how to make the state work for its conviction, the presumption of innocence is really just a nice sentence with nothing behind it. That reading of the Sixth Amendment, narrow, technical, and quietly devastating for anyone without money, held for 140 years. It took a group of 9 teenagers, dragged off a train in the Deep South, to finally force the Supreme Court to look at it again. March 1931. A freight train rattles across the Alabama countryside, hopping between Chattanooga and Memphis, the way thousands of unemployed men and teenagers did during the Depression, riding the rails because it was free, because work was scarce, because there wasn't much else to do. On board that day were 9 black teenagers, strangers to each other for the most part, ranging in age from about 13 to 20. Also on board were 2 white women. Somewhere along the route, a fight broke out between the black and white passengers over, of all things, who had the right to be in which car, and the white men involved were thrown off the train. When the train pulled into the small town of Paint Rock, Alabama, a posse was waiting, and the 2 women on board accused the 9 black teenagers of rape. There was no time to prepare, no time to investigate, no time, really, for anything except speed. The 9 defendants, who'd later become known across the country as the Scottsboro Boys, were arraigned within days. At that arraignment, the judge went around the room and, in the vaguest possible way, appointed all the members of the local bar to represent them, which is a legal way of saying he appointed no one in particular, and therefore, in any real sense, appointed nobody at all. One local lawyer showed up more out of community pressure than obligation, admitted openly in court that he hadn't prepared the case and barely knew Alabama procedure, and that was the extent of the defense. Within days, 8 of the 9 were convicted and sentenced to death. Death for teenagers, some of them barely old enough to shave, tried in a courtroom thick with the kind of public fury that makes a fair trial almost a physical impossibility. Defended by a lawyer who'd had, by his own account, no time to prepare anything. The case worked its way up to the United States Supreme Court, and in November of 1932, the court did something it had essentially never done before. Writing for a 7-2 majority, Justice George Sutherland didn't just say the trial had been unfair in some vague sense. He said the failure to provide real, effective counsel was itself a violation of the Constitution. In a capital case, he wrote, where a defendant is unable to hire a lawyer and is incapable of adequately defending himself, because of ignorance, poverty, or the sheer complexity of the law, the court has a duty to appoint one, not a token appointment made minutes before trial. A real one, with real time to prepare. It was a landmark. For the first time, the Supreme Court had said, in plain language, that the right to counsel could not just be a formality, and that indigence itself could be the very thing that made a trial unconstitutional. Newspapers across the country covered it. Legal scholars called it a turning point. But look closely at what the court actually ruled, and the limits show up fast. This wasn't a general right to a lawyer. It was a right built for exactly one kind of case. A capital case, where a person's life was on the line, where the defendant was young, poor, and essentially illiterate, where the circumstances were about as extreme as they come. The court was careful, almost deliberately careful, not to say anything about what happened in the thousands of ordinary criminal trials happening every single day in courtrooms that weren't deciding whether 9 teenagers would live or die. So the question that mattered to almost everyone else in the system was still wide open. If your life wasn't on the line, if you were just facing 5 years, or 10, or 20, did any of this apply to you at all? The answer, for now, was no. But someone, decades earlier, had already tried to fix that. And almost no one had listened. Almost 40 years before Gideon ever picked up a pencil in a prison cell, a woman had already figured out exactly what was wrong with the system, and exactly how to fix it. Nobody listened. Not for a long time, anyway. Her name was Clara Shortridge Foltz, and by the time she showed up at the 1893 Chicago World's Fair to pitch her idea, she'd already spent years breaking down doors that weren't built for her. She was the first woman admitted to the California bar, and she'd only gotten there by successfully lobbying the state legislature to change a law that explicitly barred women from practicing law in the first place. She sued a restaurant for refusing to serve her without a male escort. She argued cases in courtrooms where women weren't even allowed to sit on the jury deciding the outcome. So when Foltz stood up at that fair and proposed something called a public defender, a lawyer paid by the county whose entire job was to represent people who couldn't afford one, she wasn't a naive idealist. She'd watched up close what happened to poor defendants who walked into court with nothing and no one. Skilled, well-funded prosecutors on one side, nobody on the other. She thought that was obviously unfair, and she thought the fix was obvious too. If the state pays for the prosecution, the state should pay for the defense. It's worth sitting with how radical that idea sounded at the time. This wasn't charity. It wasn't a lawyer occasionally taking a case out of goodwill. Foltz was proposing a permanent government office. Salaried attorneys, defined responsibilities, a fixed term, funded the same way the district attorney's office was funded. A mirror image of the prosecution, built right into the machinery of government. It didn't happen overnight. It didn't happen for almost 20 years. Foltz spent that time doing what reformers usually have to do: writing, lecturing, lobbying state by state, dragging the idea from a speech at a fair into something resembling actual legislation. And in 1913, Los Angeles County voters finally approved it, amending the county charter to create the nation's first public defender's office. It opened its doors the following January with a man named Walton J. Wood as the very first public defender in American history, 4 deputies, and a secretary. It's a genuinely remarkable moment, and it's also, if you're being honest about it, a strange kind of milestone. Because notice what it actually was. One county, one office, in one corner of one state. Not a right, not a law that applied anywhere else in the country. If you were a poor defendant in Los Angeles County starting in 1914, you might, for the first time in American history, get a real lawyer paid for by the government. If you were a poor defendant literally anywhere else, the next county over, the next state over, none of that existed for you. It would take decades for other places to follow LA's lead, and even longer for anyone to ask the question Foltz had really been circling the whole time. Should this be optional at all? Should it depend on which side of a county line you happen to get arrested on? The federal government, as it turned out, was about to answer a piece of that question. Just not the way anyone expected. By the 1930s, the patchwork was getting harder to ignore. A handful of counties here and there had followed Los Angeles's lead and set up some version of a public defender. Most of the country hadn't, and in 1938 the federal government stepped in, but only for its own courts. The case was Johnson versus Zerbst, and without getting lost in the details, the Supreme Court ruled that in federal criminal trials, an indigent defendant has a right to be appointed a lawyer. Full stop. Not just in capital cases. Not just when the circumstances were extreme enough to shock the court's conscience, the way Scottsboro had been. Just If you're poor and you're being tried in federal court and you can't afford a lawyer, one gets appointed. Automatically. On paper, this looks like real progress. And in a narrow sense, it was. It's the first time the court said, plainly, that poverty alone was enough to trigger the right to counsel. No extreme circumstances required. But here's the catch. And it's a big one. Federal courts handle a small slice of American criminal cases. Bank robbery, certain kinds of fraud, crimes that cross state lines, offenses against federal law. Federal court. But burglary, assault, most theft, most violent crime, the overwhelming majority of what actually fills up American courtrooms every single day, that's state court. That's local court. And Johnson v. Zerbst said nothing at all, about what happened there. So picture the map of the country in 1938. If you got arrested for something that happened to violate federal law, you now had a guaranteed right to a lawyer, regardless of what you could afford. If you got arrested for something that violated state law, which, again, was true for the vast majority of criminal defendants in America, you were right back where you started. Maybe you were in Los Angeles County, and you got lucky. Maybe you were literally anywhere else, and you didn't. It created something almost absurd if you think about it for more than a few seconds. Two completely different versions of the Sixth Amendment, operating in the same country, at the same time, depending entirely on which courthouse you happen to be standing in. The federal government had, without quite meaning to, drawn a bright line between two classes of defendant, and left the much larger class to fend for itself. Someone was eventually going to ask the obvious question. If this right existed for federal defendants because they were poor, why didn't the same logic apply to everyone else? The Supreme Court would get that question soon enough, and in 1942, it would give an answer that satisfied almost no one. In 1942, a man named Smith Betts was charged with robbery in Maryland. He was poor. He asked the court to appoint him a lawyer. The court said no. Maryland, at the time, only appointed counsel in murder and rape cases, and robbery didn't qualify. Betts represented himself, was convicted, and eventually took his case all the way to the Supreme Court, asking the same question 100 people before him had asked. Doesn't the 14th Amendment's promise of due process require that states give poor defendants a lawyer, the same way the federal government now had to? The Supreme Court said no. And the way they said no is the part of this story that's almost more interesting than the answer itself. The court didn't rule that poor defendants never needed a lawyer. It didn't say the Sixth Amendment was irrelevant to state courts. Instead, it invented something murkier, a test. States, the court said, weren't required to appoint counsel automatically. But in certain cases, where special circumstances made a trial fundamentally unfair without one, extreme youth, mental incapacity, a case so legally complicated an untrained person couldn't possibly follow it, a judge might be required to appoint a lawyer anyway. Might, depending. If a judge decided the circumstances were special enough, sit with how unworkable that actually was in practice. It wasn't a rule, it was a mood. One judge, looking at a defendant who couldn't read, might decide that counted as a special circumstance and appoint a lawyer. Another judge, in the exact same state, looking at an equally uneducated defendant charged with an equally serious crime, might decide it didn't rise to that level and let the trial proceed without one. There was no consistent standard for what qualified. There wasn't even a consistent standard for how a defendant, who, by definition, usually didn't have a lawyer yet, was supposed to know to argue that his circumstances were special in the first place. You needed legal sophistication to successfully claim you were too unsophisticated to go it alone. It was close to circular. And so, for the next 20 years, American criminal justice ran on this doctrine, this vague, judge-by-judge, mood-dependent standard, dressed up in the language of law. Legal scholars would later look back on the special circumstances era and describe it, more or less, as a lottery. Two defendants, same charge, same state, same year. One gets a lawyer, one doesn't, and the deciding factor is essentially which judge happened to be sitting that morning and how he was feeling about the case in front of him. It's worth pausing on what that actually meant for the people living through it. It meant a poor person accused of a crime couldn't know, walking into a courtroom, whether they'd have any help at all. It meant the presumption of innocence. The whole architecture of "the state has to prove it" was, for a huge percentage of Americans, contingent on judicial mood rather than constitutional guarantee. Betts versus Brady didn't close the door Johnson versus Zerbst had opened. It just left it half open, swinging on a hinge, banging shut on some defendants and staying open for others, with no way to predict which. That chaos held for 2 decades. It took a man with an 8th-grade education, a burglary charge in a small Florida town, and a pencil to finally force the court to admit the special circumstances test wasn't working at all. Clarence Earl Gideon was not, by any conventional measure, the kind of man you'd expect to end up on the right side of history. He had an 8th-grade education. He'd spent much of his adult life drifting, in and out of prison, mostly for small, non-violent crimes. The kind of quiet, unremarkable criminal record that never makes anyone's short list for future constitutional icon. Nobody was watching him. Nobody had any reason to. In June of 1961, someone broke into the Bay Harbor pool room in Panama City, Florida, smashed a window, took some money out of the vending machines, a few beers, some coins. It was not, in the grand scheme of American crime, a big case. Gideon was arrested for it. And when he showed up in court, he did what the Constitution, in his understanding of it, entitled him to do. He asked the judge, plainly, in open court, to appoint him a lawyer because he couldn't afford one. The judge, Robert L. McCrary, Jr., told him no. Florida law, at the time, only appointed counsel in capital cases. Breaking and entering wasn't a capital case. So Gideon defended himself. He didn't know how to. He hadn't studied law. He didn't know how to cross-examine a witness or object to evidence or make an opening statement that did anything except state, plainly, that he was innocent. He was convicted. He was sentenced to 5 years in a Florida state prison. Here's where the story does something almost nobody expects. Gideon didn't just serve his sentence quietly. In his cell with no formal legal training, no law degree, nothing but a library and stubbornness, he started teaching himself constitutional law. He read. He studied prior cases. And eventually, on prison stationery, in pencil, he wrote out a petition to the United States Supreme Court, arguing that his conviction was unconstitutional, that Betts versus Brady had gotten it wrong, that the vague, special circumstances test wasn't good enough, that the Sixth Amendment meant what it said. Try to picture that for a second. Not a lawyer, not an activist, a convicted burglar, alone in a cell, betting that if he could just get his handwritten argument in front of the right 9 people, he could force the entire American legal system to change. Most petitions like that go nowhere. Most get read for 30 seconds and denied. Gideon's didn't. The Supreme Court granted certiorari, agreed to hear the case, and in a detail that still feels almost too neat to be true, the court appointed Gideon a lawyer for the appeal, Abe Fortas, a prominent Washington attorney who would, a few years later, become a Supreme Court justice himself. The very system that had refused Gideon a lawyer at trial now handed him one of the best in the country to argue that the refusal itself had been unconstitutional. On March 18, 1963, the court ruled, unanimously, 9-0. Writing for the court, Justice Hugo Black didn't just side with Gideon, he explicitly overturned Betts v. Brady, the very case that had created the special circumstances mess 2 decades earlier. The right to counsel, Black wrote, was fundamental to a fair trial. Not a luxury, not something contingent on a judge's mood. A poor man facing criminal charges needed a lawyer just as much as a rich one did. And the Constitution didn't make exceptions based on income. Florida sent Gideon back for a new trial. The same charge, the same pool hall, the same evidence. Except this time, he had a real attorney sitting next to him, a local lawyer named W. Fred Turner. And with an actual defense, someone who knew how to poke holes in the state's case, how to raise reasonable doubt. The jury acquitted him. Clarence Earl Gideon walked out of that second trial a free man. 1 prisoner, 1 pencil, 1 conviction, quietly overturned by a case that would go on to rewrite the rules for every courtroom in America. But writing the rule down was the easy part. Making it real for millions of defendants in thousands of courtrooms was about to prove a whole lot harder. Winning Gideon versus Wainwright was, in a strange way, the easy part. The Supreme Court can announce a right in a single sentence. It cannot conjure the lawyers, the offices, the funding, or the infrastructure needed to actually deliver that right to millions of people overnight. And in March of 1963, that's exactly the gap the ruling left behind. Think about the scale of what states suddenly had to build. Before Gideon, only a handful of places in the country, Los Angeles County among the earliest, had anything resembling a public defender system. After Gideon, every state in the country was constitutionally required to guarantee a lawyer to every indigent defendant facing serious criminal charges. That's not a policy tweak. That's an entire branch of government that, in most of the country, simply didn't exist yet, and now had to exist by the following Monday, more or less. States scrambled in different directions. Some built formal public defender offices, modeled loosely on what Foltz had proposed 70 years earlier. Others leaned on a patchwork of private attorneys taking court-appointed cases for a flat, often modest fee. A few tried a mix of both. There was no federal blueprint handed down with the ruling, just the requirement and the expectation that states would figure out the how on their own, county by county, with wildly uneven levels of funding and commitment. And the court, having opened this door, kept walking through it further over the next decade in ways that made the logistical challenge even bigger. In 1966, Miranda versus Arizona extended the right to counsel backward in time, not just at trial, but during police interrogation, the moment you read those now famous words. The right to a lawyer wasn't just about the courtroom anymore. It started the second you were in custody. Then, in 1972, the court went further still. Argersinger versus Hamlin involved a man named John Argersinger, convicted in Florida of carrying a concealed weapon, a misdemeanor, not a felony, and sentenced to 90 days in jail without ever having a lawyer. Florida argued the Gideon rule only applied to serious, felony-level cases. The Supreme Court disagreed. No one, the court ruled, could be sentenced to any jail time at all, even a single day, even for the pettiest offense, without having been given the chance at a lawyer. Gideon had been about felonies. Argersinger meant the right now covered the millions of low-level misdemeanor cases moving through American courts every single year. cases involving trespassing, shoplifting, disorderly conduct, the everyday churn of the criminal legal system that dwarfs, by sheer volume, the number of serious felony trials. So, within less than a decade, the right to counsel went from a narrow rule about capital cases to something touching almost every single person who could face a night in jail, from the moment of arrest through trial. It's a genuinely staggering expansion of a constitutional right in a short span of time. But expansion of the right and expansion of the resources needed to actually deliver it are two very different things. Every one of these rulings created more defendants who legally needed a lawyer. None of them came with a mechanism to guarantee there'd be enough lawyers, enough funding, or enough hours in the day to represent them properly. That gap, between the right on paper and the right in practice, didn't close in the decades that followed. In a lot of places, it's arguably wider today than it's ever been. Fast forward to today, and the picture gets complicated. The right Gideon fought for exists. It's real, it's constitutional law, and no state can simply decide to ignore it. And yet ask anyone who's spent real time inside the modern public defense system, and you'll hear a version of the same complaint. Having the right and having the resources to make that right mean something are two very different problems. Here's the scale of who actually relies on this system. More than 80% of people charged with a crime in America can't afford to hire a lawyer, which means the overwhelming majority of the criminal justice system runs on public defense, not as some marginal safety net, but as the backbone of how American courts actually function. And that backbone has been underfunded for decades. Some estimates suggest only about 2% of state and local criminal justice spending goes toward the defense side compared to what flows toward police and prosecutors. For a long time, the caseload numbers that were supposed to protect defendants were themselves badly out of date. Courts spent years relying on standards suggesting a public defender could reasonably handle something like 150 felony cases or 400 misdemeanor cases in a single year. A more recent rigorous workload study concluded those numbers were never realistic to begin with. And in response, places like Washington State overhauled their standards, cutting the recommended annual felony caseload down to something closer to 45 to 50 cases a year. That's not a minor adjustment. That's an admission that the old system had been asking defenders to do roughly 3 times too much work for years without anyone officially calling it a crisis. And in some places, it's worse than that. A 2020 survey in Utah found some public defenders carrying upwards of 500 misdemeanor cases in a single year. Do the math on that, and you're looking at a caseload that leaves a defender only minutes, not hours, to spend per client. Barely enough time to read the file, let alone build a defense. What does that actually look like for the person sitting across the table? It looks like a defender who doesn't have time to investigate, doesn't have time to go to trial, and ends up steering almost every case toward a quick plea deal. Not necessarily because that's the best outcome, but because it's the only outcome the math allows. In some counties, the shortage has gotten bad enough that defendants have waited weeks just to be assigned a lawyer in the first place, which means the clock on their constitutional right is ticking before anyone's even in their corner. In a few extreme cases, offices have had to formally declare themselves unavailable for new cases altogether, just to keep from violating their own ethical obligations to the clients they already have. So the right is there. Gideon's name is still good law, cited in courtrooms every day. But a right that technically exists and a right you can actually use aren't automatically the same thing. And 60 years after a prisoner's pencil forced the country to make that promise, plenty of people are still waiting to find out which version of it they're going to get. Step back from all of it. The pool hall, the pencil, the 9 boys on a train. And this stops being a story about the law. It becomes a story about who a country decides it owes something to, and what happens when that debt goes unpaid for a while. Every one of these fights, from Clara Foltz standing up at a fair in 1893, to a Scottsboro courtroom in 1932, to a Florida cell in 1962, comes down to the same uncomfortable question. Does equal justice under law actually mean equal? Or does it mean something closer to justice, if you can afford it, and something else, if you can't? America has spent 2.5 centuries answering that question differently, depending on the decade, the state. Sometimes just the judge you happen to draw that morning. Gideon's win in 1963 wasn't really an ending. It was the country finally admitting, out loud, that the second version of that question had been the true one for far too long. And every chapter since, Miranda extending the right into the interrogation room, Argersinger extending it to a single night in jail, and now, 60 years later, states scrambling to fix caseload numbers that were broken from the start, is really just the slow, unglamorous work of trying to make that admission mean something in practice, not just on paper. Which brings it back to right now, because that work isn't finished. Not even close. When the majority of criminal defendants in this country depend on a system that gets roughly 2 cents of every criminal justice dollar, when a defender can be handed caseloads 3 times higher than any study says is manageable, the right Gideon fought for is still, in a lot of courtrooms, more promise than practice. The pencil worked. The follow-through is still a work in progress. So the next time you hear those 8 words, if you cannot afford one, one will be provided for you. It's worth remembering they weren't always true. They became true because a drifter with an 8th grade education refused to accept that they weren't. And whether they stay true, for the next person sitting in that chair, depends on whether anyone still cares enough to keep making sure the promise gets kept. If you liked this one, there's a whole system of things you use every day that were built the exact same way. Quietly, unevenly, usually because somebody refused to give up. Subscribe if you want the next one, because the systems you never think about are the ones running your life.